Joining us now to take a look at the Supreme Court confirmation process at all is David Levine, professor of constitutional law at UC Hastings. How has this process changed or evolved over the years?
Sure. Well, once upon a time, it was really perfunctory. Sometimes the Supreme Court nominees would not even come into the Senate. It would just be approved. Remember, what we're doing is advice and consent. You think of people like Ruth Bader Ginsburg and Antonin Scalia, where they were voted in by 93 to nothing, 94 to nothing. The standard at that point was, are they qualified? Do they have the background, the temperament, the experience to do the job? And also, there was a lot of consultation in advance. The president would talk to senators, indeed sometimes talk to Supreme Court justices, and make sure that the person they picked was right. What changed, everybody says, is it was Robert Bork.
Do you agree with that? Was that the change, or was it evolving?
Well, it may have been evolving, but I really think that there was a difference there because with Bork, the shift was not just was the person qualified, because undoubtedly he was absolutely qualified, but rather were his views so extreme that it was out. That's where you started to hear this out of the mainstream sort of statement.
Now, at the same time, the division on the court became more 5-4-5-4. So a Bork or somebody else could be increasingly the swing. So ideology became a bigger player. Is that right?
I think it did, but I think it's also that as the presidents picked more ideological people, that's part of it as well. If you look back to somebody like Warren Burger, who President Nixon put on the court, yes, there was going to be a shift from Chief Justice Warren to a new Chief Justice Warren Burger, but Burger was still considered to be well within the mainstream, not as ideological. So when you get somebody like Bork, the feeling, I think, upon the Democratic senators was that this was somebody who was so ideological, so extreme, that the standard inevitably shifted.
So that was one shift. The second shift is Anita Hill. That's where we got into temperament, and that's how we wound up here, right?
Right, that's right. That's right. With Professor Hill, we had this explosive situation of whether or not just was Clarence Thomas fit as a judge, but whether he had conducted himself appropriately.
The issue of temperament,
sure,
which has long been a standard, but now is in our age is taking on a different dimension.
Well, I think that these things came up in a way that maybe either hadn't come up in the sense that maybe people didn't complain before, or that people had been better vetted. I also think of, just to jump to one other, John Tower, when he was nominated as Secretary of Defense, he lost that position basically because he was a drunk. He was a senator, and so sometimes temperament came in. But with Anita Hill, without a doubt, this idea of sexual harassment exploded into people's consciousness. It had been discussed before that, but she's the one who brought it to the fore.
Now, these hearings for confirmation are outside of the legal realm. Mm-hmm. This is a political process. It's the Senate.
Right.
Is there a standard that this candidate either has to pass or fail, or is it strictly subjective?
It's strictly subjective. There's nothing per se about it. All the Constitution says is that the president nominates and then acts with the advice and consent to the Senate. Under the current rules, all we need are 51 senators, or technically actually 50 would be enough, and that's all. So anything that will convince a majority of the Senate that this person is qualified is enough. There's no firm standard on this.
All right, so we have the decision on the top court that decides all the laws of the land essentially boils down to politics.
You bet. That's it.
That's it, and that's what we're going to be seeing, and we're going to be staying tuned to it. When you ask people about these hearings, a lot of it, you can tell their response by where they stand on Roe v. Wade.
Right.
The idea of choice/abortion. Mm-hmm. Is the Supreme Court going to repeal Roe v. Wade?
Not right away. All right. So if we assume that Judge Kavanaugh becomes Justice Kavanaugh, and that the
or someone of his
persuasion, somebody on that list that President Trump was handed from the Federalist Society, somebody who those people think is a reliable vote to overturn Roe versus Wade. All right. So let's assume somebody's there, whether it's Kavanaugh or somebody else. So that's number one. Number two, what will happen? Well, remember, you still need 5 votes. You can't just have 1 or 2 people saying, we think that Roe versus Wade is terrible.
5 votes on the Supreme Court.
5 votes, absolutely. So here, this is why we talk about Roberts becoming the swing vote. Kennedy having left, he was in the middle, now Roberts is in the middle.
Is there is it set up for Roe v. Wade to be repealed? Because I hear conflicting things on that.
Okay. Sure.
Is it?
Well, set up in a couple senses. Number one is the Supreme Court has to have a case, right? There's got to be a case. The Supreme Court can't just decide, wake up one morning and decide, well, you know what? We had coffee this morning. We think we'll overturn Roe versus Wade this morning, and then we'll go play tennis. That's not how it works. You have to have a case. So there have to be cases that are bubbled up from lower courts. Now, those cases are actually happening. The way they're happening is that state legislatures in conservative places are passing legislation that they know would violate the current standards under Roe and the later cases. And they deliberately are doing that so that cases will be created. So abortion clinics, Planned Parenthood, the others are challenging those statutes. Lower courts are saying, you know what, they're unconstitutional. Then those get appealed. So the Supreme Court then gets presented with cases that they could choose to take. Now, the rule is 4 justices have to take a case for review, but you need 5 justices to do anything. So you're not going to take a case as a group of 4 until you're convinced that you've got that 5th vote. So where are you going to get that 5th vote? It's going to be Roberts. So one thing that could happen is that they'll be chipping away at that right. The current standard is, if there's legislation, is it an undue burden on the woman's right to choose? So what a majority of 5 could do is they could say, well, a longer waiting period is not an undue burden. Shortening when you can have an abortion, that sort of thing is not a quote-unquote undue burden. And you could chip away, chip away, chip away.
And that is what the fear is that there'll be a constant chip away? Okay,
Right.
Second issue is guns.
Right.
Real short on that. We don't have a lot of time.
Sure.
Is there realistically something there anybody's going to change the Second Amendment?
Well, they're not going to change it, but the issue will be to interpret the Second Amendment. Here, Justice Thomas is the one who has been banging the drum on this. He's been upset in several cases that the Supreme Court has not wanted to take cases on review. Without Kennedy, who seemed not to be a reliable vote, but with somebody like Kavanaugh, who would be a reliable vote, there will be extensions of the right to bear arms.
We've only got a couple of seconds left. How big are these 2 issues playing behind the scenes in these confirmation hearings?
They're enormous, because the whole game is that President Trump is selecting his nominees from a list that was picked by the Federalist Society to be reliable right-wing votes, and that's what they're shooting for.
All right. Well, it's going to be, whether it happens this time or the next time, these hearings, it's an ongoing conflict that doesn't show much signs of resolving itself.
Not now. No, not for a while.
David Levine, UC Hastings law professor.